Okay, good afternoon, everybody. I hope we're okay to start. Welcome to this meeting, which has been organized by the Arrested Lawyers Initiative, the International Bar Association, the Italian Federation for Human Rights, Justice Abroad, and the Italian National Bar Association. We will be hearing from experts about the plight of the estimated 1,600 lawyers who've been detained in Turkey in recent years, many of whom have been jailed following the failed coup in 2016, and about the conditions endured by more than 600 lawyers who remain in prison today. Lawyers are not the only victim of President Erdogan's purge of opponents, but they have been among those most consistently targeted. They have been charged with terrorist-related offences, particularly because the authorities wrongly identify them with the political views and alleged crimes of their clients. There are claims of torture and mistreatment. Human Rights Watch has reported that stress positions, sleep deprivation, severe beatings, sexual abuse and rape threats have been used against those held in custody. One lawyer, Erdem Semih Yildiz, for example, has said during a court hearing, that he had been repeatedly slapped and beaten while he was in custody in Ankara's police headquarters. Others detained have included İdil Eser, the director of Amnesty International in Turkey, and the writer Ahmet Altan. We are also going to hear from a panel of distinguished lawyers and campaigners who are trying to prevent this abuse by punishing those directly responsible for persecuting those held in Turkey's overcrowded prisons. One of the most promising developments for enforcing respect for human rights through legal measures imposed from abroad has been the Magnitsky Sanctions regime, pioneered by Bill Browder and most recently adopted by the EU. Other countries, such as the UK's newly introduced Global Human Rights Sanctions, have copied the United States Magnitsky Act. We will be hearing how these schemes can be used to prevent torture and abuse in Turkey. My name is Owen Bowcott. I used to be The Guardian's legal affairs correspondent. Before covering law, I worked on the newspaper's foreign desk and was a regular visitor to Turkey in the late 1990s. I remember traveling to Diyarbakir in the southeast and going in search of the local offices of the IHD, the country's Human Rights Association, to inquire about reports of brutality by the security services. I found the building, climbed up several flights of stairs, and there was the IHD, officially closed by government order. But what was so striking was that the office was shut down by a piece of string and a single sheet of paper carrying a document from the government that had simply been hung on the door handle. That such a flimsy device could be so powerful implied a fear of authority that was alien to me. I hope this afternoon's session will help to challenge such restrictions on freedom and civil rights. We have a large number of expert speakers and then intend to take questions at the end. We will hear from Baroness Helena Kennedy, QC, Director of the International Bar Association's Human Rights Institutes. Then we're hoping to hear from Bill Browder, head of the Global Justice Campaign, who will update us on the progress of legislation around the world. Amanda Stryer of Human Rights First will talk about the use of targeted sanctions through US legislation. Dr. Kerim Altinparak, Vice Chair of Turkey's Human Rights Association, will explain how lawyers and journalists are being treated in the country. Kevin Dent, QC, a UK barrister who is representing the Turkey Human Rights Accountability Project, will tell us about the Gezi Park cases and the changes to UK law. He's working on a submission to the Foreign Office. Michael Polak, who's working with him, another barrister, will also give more details about the British human rights sanction regime. Elenora Mongoli, Vice Chair of Italian Federation for Human Rights, will explain how the new EU sanctions regime might be used to protect human rights defenders. And Francisco Caya, Chair of the Human Rights Committee of the Italian National Bar Association, will talk about her experience helping lawyers in Turkey. At the end, we'll have questions, and If you can send questions eventually via the chat function on the screen, and you should be able to unmute yourself as well. Now, over first of all, please, to Baroness Helena Kennedy. Thank you.
Thank you, Owen. I'm a barrister and Queen's Counsel, and I've been a practitioner here in the United Kingdom for many, many years, over 4 decades. And in the last 2 years, I have been the director of the Institute of Human Rights for the International Bar Association. Now, the International Bar Association is an umbrella organization. It was set up in 1948 after the Second World War, and it was to draw together lawyers around those issues that were very prevalent at the time, which was about creating standards for the rule of law and the protection of human rights around the world. And of course, you'll remember that the Universal Declaration of Human Rights had just been created. There are 187 bar associations around the world that are underneath that umbrella, and many thousands of law firms and individual lawyers are members of the IBA. So it's a membership organization with a great deal of influence and power. Within it, there is this Institute of Human Rights, which enjoys a level of independence. I'm not answerable to anybody, and so it means that the Institute can call out behaviours in countries, even where there has been a level of, if you like, capture of bar associations and even judiciaries by the government. And one of the roles that we play is in calling to account places and governments that are eroding human rights and the rule of law, and also protecting lawyers and judges who do come under attack. Now, Turkey has been a great source of concern to us during all these years, and Owen has described the high number of lawyers that have been attacked and have been imprisoned. In fact, there are a whole set of them who are currently serving more than almost 3,000 years between them in the lengths of sentences that have been passed on them. And you've heard about the treatment of those lawyers. But of course, they don't stand alone. The intellectuals, the judges in huge number were arrested after the coup, academics, journalists severely attacked. And so, these are all signals, of course, of populism. What happens when you have populist governments is there's always that trajectory. The leaders of populist governments providing simple solutions to complicated issues almost invariably don't like criticism. They go after their political opponents, they go after the journalists who write freely about them, they go after the lawyers who represent the journalists or represent those who are organizing in civil society, they go after intellectuals, and so on. And so they go after, of course, their judiciary, if the judiciary seek to uphold rights. And so that classic trajectory can be seen in so many places in the world, but by God, can it be seen currently in Turkey. The International Bar Association's Human Rights Institute has a number of focuses. I mean, we deal with thematic areas, of course, around extrajudicial killing, arbitrary arrests, erosions of rights generally, and the whole gamut. But most particularly using our expertise as lawyers, addressing these things, particularly within the administration of justice. One of the things that we've been doing recently is we've been running a high-level panel of legal experts on media freedom, because if people aren't well informed about what's going on in their nations and don't know the abuses that are taking place, the corruptions that are taking place, and the ways in which their own avenues for redress are disappearing, then they will never be able to assert their rights. And so that issue of media freedom is at the heart of a big project that we're doing, which is now a sort of multilateral project. It started off where we had the UK and Canada involved. It's under now got the support of UNESCO, and so it sort of acts as a sort of gathering institution. And we've now got 40 countries around the world have signed into this, making a commitment to media freedom and to the ways in which governments might be called to account, and there might be redress and protections for journalists. So I wanted to talk here about the use of targeted sanctions. I mean, one of the problems that we all have now is the situation with regard to the UN and those, if you like, those methods that were put into place with the sort of, if you like, the idea of an order, a sort of, you know, based on the rule of law. That has been disintegrating, and it wasn't helped by the fact that we had Trump in the White House, who was not very respectful of international law or any of those, you know, things that basically would provide a unifying front on protecting societies and individuals. And so the UN has been on the back foot. Hopefully it will be reasserted now that there's a different administration in the United States. But of course, it's not just about the United States. It's about the fact that we've seen this along with the pandemic. We've also seen another pandemic, which is the rise of populism in so many places. And Turkey is a prime example. I want to pay a bit of a tribute here now to Bill Browder, because I've known Bill now for, I think, something like 10 years. And he really has been the pioneer. He's fathered a change in international law, which is that to give some teeth to international law, because we are not seeing the international community coming together adequately on horrors like what's taking place in Turkey. And so you have to find other mechanisms, and we have to be inventive and creative as lawyers to find ways of calling abuse to account. And the silence of the international community is echoing large around the world. Bill, in creating the sanctions, this novel sanctions regime, is saying, go after the individuals. Don't wait and go after nations and make the ordinary people of a nation suffer. Go after the people who actually are perpetrating these abuses. And almost all of these people who run populist governments quietly have their money elsewhere, or they have their policemen who have money elsewhere and keep their assets elsewhere because they worry that their time might come when they might have to exit and have an exit strategy. So they keep their monies in other places. They often have assets here in London, but they have them in Manhattan, they have them in the south of France, they have them in many different places. And so what we have to do is go after the assets that the powerful have, particularly those who are the ministers of justice, the people who are the leading figures in a nation, the people who are the people who run the prisons, the people who are running the prosecutorial services. And so you go after you identify the individuals who are going to be hard hit by this stuff, and you don't let them have visas. You freeze their assets. You don't let them send their children to universities in the United Kingdom or to school, the private schools in the UK. And so you go after the people who actually are the decision makers that are, in fact, perpetrating these horrifying abuses against so many people around the world, but particularly today we're talking about Turkey. So it's about giving teeth to international law. And one of the things that we did doing on this media freedom project was to actually make that one of the first pieces of work we've done. We're looking at creating a whole set of mechanisms in order to empower human rights organizations, lawyers, etc., to be able to go after those who are committing this kind of outrage. And that we've published a report, and I would advise you all to take a look at it. Amal Clooney was our main writer of it, and along with other lawyers who sit on an expert panel from around the world, from Latin America, from Seoul, from India, Pakistan, from everywhere. Really brilliant lawyers who come together to create a strategy for dealing with this kind of abuse. So I really just wanted to kick off your discussions by talking about the ways in which we mustn't feel powerless in the face of the powerful. We've been holding, the IBAHRI Human Rights Institute has been running a trial watch on the trial of Osman Kavala. Not a lawyer, but we're collaborating with lawyers around that. He was the chairman of the Open Society Foundation in Turkey, and it was building civil society and maintaining civil society, and those involved in the Geza Park matters will know exactly who he is. But he has been appallingly treated. And of course, the idea is to set him as an example to anybody else who steps forward to act as a pro-democracy voice and to be protecting civil society. And so the message to everybody is, this is what happens to you. And that, of course, again, is what autocratic leaders in countries do. So I want to just say to you all that, acting as lawyers, I mentioned earlier on that I'm having to leave now because we're expecting some United States to take up a much different position with regard to the murder of Jamal Khashoggi, the journalist. And I happened to be I was on the expert group that accompanied Agnes Kalamar, the rapporteur, to Turkey. So I heard the evidence. I heard the tapes of what happened to Jamal Khashoggi. I heard the intercepted phone calls. And all I can tell you is that if we can't secure justice in a case like that, where there actually is verbal evidence, it shows you how hard it is in any other kind of case. We have to be drawing together the international community around these issues, and we have to get tough. And Bill Browder has invented something where we have to get it spread everywhere. The EU has signed up now, and Bill will talk about the other nations that are coming on board. But we have to actually be calling it out here in the UK as well, to make sure that people are put on the sanctions list, and that we aren't pusillanimous about it because of trade and so on. We've really got to take a stand in the world about justice and about the rule of law. Thank you all.
Thank you very much, Helena. That's a very good opening for us, and I hope you'll have luck with your Saudi case as well. That's very kind. Thank you. Our next speaker is Bill Browder himself, who has pioneered many of the efforts that we're going to be looking at through his Global Justice campaign. And he's going to report about how that's been developing around the world. So if I could hand over to Bill, who I believe is in the room.
I'm here. I'm here. Thank you. Thank you very much. Before I start, I just want to make a couple of shout outs to people who are here with us today. Helena is just gone, but I should point out that she has been one of the biggest and most effective advocates in the House of Lords and in general parliamentary circles for a UK Magnitsky Act. And we probably wouldn't have had it not been for her stalwart advocacy. I see Jeffrey Robertson QC on this call. I don't think he's speaking, but I see him attending. Jeffrey Robertson has been for 10 years my partner in advocating for the Magnitsky Act, and we're almost at the point of having an Australian Magnitsky Act. And his credibility and gravitas and testimony and legal work has made that possible in addition to various other places. I see, we don't know each other, Amanda, but Human Rights First is an incredible organization who are responsible for a third of all US global Magnitsky sanctions. And it's with a model that they've created needs to be replicated around the world. And then we also have the Italian Helsinki Commission, who's been very helpful. And I know a number of your representatives. So I just wanted to shout out to all of people who have been helpful to us in our campaign. I'm probably the only non-lawyer on this call. And perhaps that's been an advantage in coming up with the idea of Magnitsky sanctions. All of you lawyers like to work within the law. And when Sergei Magnitsky was murdered in 2009, I wanted some type of redress for his killing. And I looked, and in Russia, because the Russian government killed him, and it was effectively a political killing, they weren't going to provide us with any justice inside of Russia. And so we said, how do we get justice outside of Russia? And I looked at all the mechanisms of justice. And everyone said, you should go to the European Court for Human Rights. So we went to the European Court for Human Rights and discovered that they only issue judgments against a country, not against any individuals. And that was highly unsatisfactory, since we know who the individuals were who killed Sergei and tortured him. And by the way, it takes like 8 years, and in the end, the best outcome is a £50,000 or €50,000 award for the family. And in our case, we got that judgment, got that award 8 years later, and they still haven't paid it. And so that's not justice. I went to the International Criminal Court and to the Chief Justice at the time, and I told him the story of Magnitsky, and he said, "I'm sorry, you need 100,000 dead, not one dead, to get any kind of case here." I looked at universal jurisdiction, which is a concept that says that if a crime is so heinous that it can be, even if there's not normally jurisdiction in a foreign country, it can be tried in that foreign country. And there's lots of universal jurisdiction statutes on different books, but when it comes to reality, none of them ever get implemented. And so the best outcome in my case with Sergei Magnitsky's murder was to get statements from governments expressing their dissatisfaction. And I knew that that was going to be meaningless in the case of Russia. And so I said, if we couldn't get justice, if there's no concept of justice, if there's no mechanism for justice, then we need to create one. And this is where my background as a business person comes in. I understood that the crimes that are committed, most crimes that are committed in Russia and other places, are committed by people who are corrupt, and they have money abroad, and they value that money abroad. And as Helena said, when they all know that their regimes are eventually going to come to an end, and when they do come to an end, they want to flee abroad to the safety of the UK, and they want to have their money safe in the UK and other places. And that's when we came up with this idea, which is that if we could freeze their assets and ban their travel, then these bad guys and women, for that matter, bad guys and bad women, wouldn't be able to flee and wouldn't have that security. And we got that was the genesis for the Magnitsky Act. And the Magnitsky Act started in the United States. The first version of the Magnitsky Act came in 2012, just for Russia. It was just a specific piece of legislation for Russia. And the moment after it was passed, Vladimir Putin went out of his mind, and he banned the adoption of Russian orphans by American families. And then he made it his single largest foreign policy priority to try to repeal the Magnitsky Act. And the two senators who were the main co-sponsors, Senator John McCain and Senator Benjamin Cardin, looked at each other and they said, well, wait a second, if Putin got so mad about this, then clearly other dictators will be equally mad about it. Why don't we broaden this out? And they introduced the Global Magnitsky Act. And the Global Magnitsky Act was passed in December of 2016. Subsequent to that, actually on the same day as that, the Estonian Parliament unanimously passed the Estonian Magnitsky Act. In October of 2017, the Canadian Parliament, the House of Commons and the Senate unanimously passed the Canadian Magnitsky Act, then the Lithuanians, then the Latvians, then the British. And we now have 31 countries with Magnitsky Acts, most recently with the European Union that passed it in December. The most important thing about the Magnitsky Act is it works. And we know it works from all sorts of anecdotal situations, but for this call, the most relevant one is it works in Turkey. The US applied the Global Magnitsky Act in relation to an American pastor who had been wrongly imprisoned in Turkey, and they applied it towards the Justice Minister and the Interior Minister of Turkey. And within moments after they applied it, Pastor Brunson was released. And it was, I think it was actually sort of badly applied in the sense that it shouldn't be used as a strategic tool, it should be used as a justice tool. But be that as it may, the fact that it was applied to Turkey and it led to an immediate outcome gives you some sense of how important it would be in this case, where instead of one person being released, you've got literally hundreds and hundreds of people unjustly in prison that need to be released. In terms of where we are at the moment, as I mentioned, there are 31 countries, 27 countries of the EU, United States, Canada, UK, and Kosovo, sorry. Don't ask me why Kosovo, but Kosovo is the other country. On deck, as I mentioned, we have Australia, Japan, New Zealand, and Taiwan. I believe Australia is coming up reasonably soon. And the most important thing to do now is to come up with very credible evidence packages to submit, and I would argue to submit at the same time to all the countries, to all the main decision makers, of terrible atrocities that have been committed and the evidence and names of the people who were involved in perpetrating those atrocities. That's how you get people on the Magnitsky list. And it may not be possible to do it for all 600 people that have been imprisoned, but my advice would be to pick out the really obvious and most horrific cases and the ones with the best evidence, and submit the documents in unison to all the countries. And it's nice that we have the Human Rights First representative Amanda here, who maybe can talk about that. But that is the key to that. And while submitting it, make it well known and publicize who you're asking to be sanctioned, and what you're asking, what they did, and what evidence you have. And just the conversation is often a sanction itself, not to mention the actual result. And so I think I will leave it at that. I'm not going to be able to participate for the full 2 hours, but I'll be here for the first hour if I can be helpful. Thank you.
Thank you very much, Bill. That's very heartening to hear, and that the precedent involving Turkey in the America's use of the Act will presumably have sensitized the Turkish government to the potential powers of Magnitsky Acts. Next, as on our program, is Amanda Strayer of Human Rights First, who will talk about the use of targeted sanctions that have been achieved through American legislation so far. So I'll pass over to Amanda next.
Thank you, Owen, and thank you, Bill, for the kind words for our program. Good morning, everyone, and hello from Washington, D.C. I'd like to also thank our host for today's event for the invitation to join you all today. My name is Amanda Strayer, and I'm an attorney with Human Rights First, which is a research and advocacy non-governmental organization which is focused on ensuring that the U.S. government upholds its human rights obligations and that the protection of human rights is at the heart of U.S. foreign policy. So in my role with Human Rights First, I help coordinate a coalition of hundreds of human rights and anti-corruption NGOs around the world who are interested in advocating for the use of sanctions tools like the Global Magnitsky Act to hold perpetrators accountable. So together we work with NGOs to assist them, as Bill was mentioning, in developing comprehensive, credible, evidence-based case files documenting alleged crimes by human rights abusers and corrupt actors, and then work to submit these files to the US government and to other foreign governments with similar sanctions programs, as has been discussed. So we provide training and advice to partner organizations to help them put forward the most credible, corroborated case files to the US government. And through our close working relationships with the US Department of the Treasury and State, we've developed a template that helps NGOs provide the information the US government needs to consider taking action on sanctions recommendations. And we'd be very happy, of course, to work with any of you who may be considering filing a case under the US Global Magnitsky program. So I'd like to spend a little bit of my time today providing a bit of a background on the US Global Magnitsky Sanctions program, how it works, who can be sanctioned, and what NGOs and lawyers should be considering when they're thinking of who to recommend for sanctions. So the Global Magnitsky Human Rights Accountability Act was passed in December 2016, and the executive order that implements that act, Executive Order 13818, was issued the following year. And together, the act and this executive order provide the legal framework for the US Global Magnitsky Sanctions Program. In the 4 years since these laws have come into effect, the US government has sanctioned 246 individuals spanning 34 countries, which is very heartening for us to see that this tool is being used and being used regularly by the US government. And these sanctions result not only in the public announcement of the sanctions, which has the name and shame factor to it, but more concretely results in visa restrictions and asset freezes for any assets that the perpetrators might have in the United States. So what these sanctions cover, they're meant to address, quote, serious human rights abuses and corruption. On the human rights side, generally these sanctions are reserved for acts of physical violence against victims, things such as extrajudicial killings, torture, cruel and human degrading treatment and punishment, rape and sexual violence, enforced disappearances, in cases of prolonged arbitrary arrest and detention. Those are generally where we see these sanctions programs being most frequently used. And many of the cases also involve a pattern of ongoing serious human rights abuses indicative of widespread or systematic abuses. So for example, the US government recently sanctioned several top-ranking Chinese officials and entities for their involvement in human rights violations amounting to genocide against the Uyghurs in Xinjiang and other minorities. But this isn't always the case, as has been mentioned earlier too, in the case of Jamal Khashoggi. Following his murder, the US government sanctioned 17 Saudi Arabian officials who were involved in perpetrating this killing. And so there, it's just the case of one killing wasn't sufficient to trigger a sanctions designation. And we'll see, pending today's announcement from the United States, what additional actions may perhaps follow from that. Unfortunately, however, the law is not meant to address every type of human rights abuse or violation. So for example, abuses that violate the rights to freedom of expression, assembly, or association are not covered specifically by the law, nor are acts of religious persecution, unless there's an act of overt violence as part of that persecution or part of the infringement of these other rights. Additionally, we've seen the US government recognize that there are strong links between human rights abuses and corruption, and numerous sanctions designations have been made on the basis of corruption where the sanctioned individuals were also involved in human rights abuses. So a couple examples that we've seen in Uganda, there were 2 judges who were sanctioned for taking bribes as part of an adoption scam, whereby children were taken from their parents on the false pretense and promise of special education opportunities in the United States, where those children were then offered for adoption to US families. So the judges were sanctioned for their corrupt act of taking bribes, but obviously they were involved in human rights abuses against the children in these families. Likewise, in the Democratic Republic of the Congo, we've seen businessmen Dan Gertler was sanctioned for his corrupt mining and oil deals with then President Joseph Kabila, which deprived the DRC of $1.36 billion just between 2010 and 2012 alone. And that obviously had a huge impact on the country and the ability to protect human rights in that country. I think that amount was could have funded half of the country's health budget just during that time period. But again, Gertler was sanctioned on the basis of involvement in corruption, though his actions clearly had human rights repercussions as well. So in looking, considering using Global Magnitsky to address human rights abuses, we encourage folks to also be mindful and consider whether there might also be corruption at play in the issues that you're looking at and that you can raise with the US government. So once you've identified specific sanctionable abuses, obviously the next consideration is who can be sanctioned under the law and held accountable for these abuses. And under GLOMAG, there's several different grounds for culpability for human rights abuse. There's the very standard culpability of someone being responsible for, complicit in, or directly or indirectly engaged in the abuse. But additionally, the GLOMAG has a status-based designation. So a person can be sanctioned solely because they are a leader of an entity or organization whose members are perpetrating human rights abuses, even if that person themselves is not directly involved in the human rights abuses. So for example, a few months ago, the US sanctioned the former Deputy Minister of the Interior in Yemen, a man by the name of Abdul Hakim al-Kawani, who was responsible for detention facilities and security forces that were arresting, detaining, torturing, and raping women who opposed the Houthis under the pretense of a policy to address prostitution and organized crime. So while al-Kawani himself did not directly perpetrate these crimes and abuses, the Ministry of the Interior had ultimate authority over the individuals who were perpetrating the abuses. And because al-Kawani was a leader, a high-level leader within the Ministry of the Interior, the US government was able to target him for sanctions. And finally, the final ground for culpability would be any individuals who are providing material assistance, sponsoring, providing support for human rights abuses. These are all grounds for sanctions, as well as attempting to commit any of the sanctionable crimes. And on this note, I'll just say it's important to remember too that both natural and legal persons, so entities, organizations, et cetera, can be sanctioned under the US law. It also applies to both state and non-state actors. So we've seen this tool used in Libya against the Khaniyat militia and its leader for murdering civilians, torture, and forced disappearance and displacement. So you're not solely limited to government actors. But one question we do often hear is how senior are the officials who are sanctioned by the US government, and can the leader of a country be sanctioned? Generally, we've seen the US government's been very willing to sanction individuals who are quite senior in government. For example, I've mentioned several of the top leaders in Xinjiang, as well as top leaders in the Burmese military have been sanctioned for their role in the genocide against the Rohingya. However, it's very, very unlikely the US would ever sanction a sitting head of state, but they would potentially consider it for a former head of state. So we saw a couple years ago, the former president of the Gambia, Yahya Jammeh, was sanctioned for decades of human rights abuses, including ordering the killings of journalists and opposition members and a local religious leader, among others. And these sanctions against Jammeh came less than a year after he left power in 2017. So, to the extent that you're looking at heads of state, very unlikely it would happen, but potentially after they've left office, they could be targeted. I think the final component of the Global Mag that's really important to keep in mind too is in the US, it is a discretionary tool. It's not a mandatory measure for the US to take. The US considers Global Magnitsky sanctions as a way to encourage behavior change and not as a punitive tool. So they're looking to use it in very recent cases and one where there's a strong national interest for the US to act. So part of the role of advocates and lawyers working to submit these case files is to help spell out to the US government exactly why designating these particular perpetrators for these particular abuses is in the US national interest. So these arguments can take many different forms. For example, does the perpetrator have ties to the United States, either through assets that they hold here, frequent travel to the United States, family that are here, et cetera. Identifying any information along these lines can help demonstrate that sanctioning this particular individual is going to have a real impact on them, which is something the US government is keen to use this tool in ways that are impactful. Other things that you might consider are the foreign policy reasons why sanctions might be the right tool in this case. So for example, could the sanctions send a targeted message to a government or to a military unit? Could they isolate an individual spoiler? Could they help reduce future abuses within a particular unit or deter other actors from committing similar abuses? Unfortunately, as we know, there's all too many incidents of human rights abuses around the world today, and it's not possible for the US to sanction every single bad actor out there. But by building a strong argument as to why it's important for the United States to take a stand, why it's in their national interest to take a stand to target a specific person, will go a long way towards strengthening your case. And so I'll kind of wrap up here. I mean, as you know, we're still in a period of transition in the United States as the new Biden administration begins to implement its own foreign policy priorities going forward. And we haven't seen any global Magnitsky designations under the new administration yet, but we do expect it will continue to be a key feature of US foreign policy in the years ahead. The law has consistently enjoyed broad bipartisan support here in the US, and we know that the Biden administration does view targeted sanctions as an important part of their foreign policy toolbox, and one they're seeking to use in more effective and multilateral ways with foreign partners like the UK and the EU and Canada. Then the Treasury and State Department are eager to continue working with civil society to receive information and recommendations that can lead to sanctions. We've seen a few early indications that the Biden administration may also consider using the tool in new ways, such as to respond to human rights abuses that have been largely overlooked in the past, such as targeted violence against LGBTQ persons. We're also hopeful to see more sanctions that address issues that have also been overlooked to date, such as gender-based violence, child victims, those who are fighting for climate justice and under attack. And here, civil society, I think, has an important role to play to bring forward strong case files for sanctions that can help the US government identify the areas where sanctions can make a real difference for the most marginalized and vulnerable victims of human rights abuses. So my colleagues and I at Human Rights First, we'd be happy to work with you and your organizations to provide additional training or to discuss any cases you might be considering filing and offer guidance and advice through that process. And so with that, I'll conclude and thank you again for the opportunity to speak with you today and look forward to any questions.
Thank you very much, Amanda. That's great to hear how widely they're being used already in the States, particularly for us in Britain, where they're novel, and we hope they will become more potent as the government gets used to them. Thank you very much. And our next speaker is Dr. Kerim Altıparmak from the Human Rights Association in Turkey, who will tell us about the conditions and situation of lawyers in Turkey at the moment. Thank you.
Thank you, Owen. I'm the only person speaking from Turkey, a kind of endangered species, I guess. I was asked to talk about lawyers and human rights defenders' situation in Turkey in 7 to 10 minutes, and I realized that it was impossible. So I decided to summarize what happened just last week, first in Turkey against human rights defenders, and then I'll try to summarize what is happening before the European Court of Human Rights and afterwards, because whether international justice is working about Turkey, we need to look at the most developed human rights system available in the world, Strasbourg, and unfortunately we will see that we can't get a lot from the court so far. Last week, 3 prominent human rights defenders were convicted in 3 different cases. These 3 cases symbolize what's happening in Turkey. So although it happened last week, if we did this meeting next week, we could talk about another 3 similar cases happening. So it's not just a coincidence that these 3 cases happened last week. The first case is about Mr. Ömer Faruk Gergerlioğlu. He was convicted on charges of making terrorist propaganda for retweeting a news story about the Kurdish conflict and the collapse of the peace process. Mr. Gergerlioğlu was a public servant, medical doctor, and he was dismissed during state of emergency. Later, then, he was elected as an MP for HDP, the opposition party, and he's the most prominent human rights defender at the parliament. Last week, his case started before he was elected an MP, but in an irregular way, courts continued the case even after he became an MP. And this is one of the discussions before judicial authorities, whether an MP can continue to be tried after the election. In any way, Court of Cassation approved the decision against him, and he received 2 years, 6 months imprisonment term. And now if the parliament reads the judgment at the parliament, his immunity will be lifted and he will go to jail just for sharing a news. This, by the way, this news is still online, and those who wrote the article have never been prosecuted for writing that. But Mr. Gergerlioğlu is an important person, not because of his routine activities, but he reported last December that female suspects and detainees had been subjected to humiliating strip searches by police in provinces across Turkey. His allegations were supported by a considerable number of prisoners who described their experiences of systematic sexual violence at the hand of the police. But Interior Minister Süleyman Soylu denied them and accused Mr. Gergerlioğlu of being a terrorist. And this is not surprising, I guess. The second case is from Istanbul, this time Eren Keskin. Eren Keskin was sentenced to 6 years and 3 months in prison for membership to an illegal armed organization. She was supporting Özgür Gündem, a pro-Kurdish newspaper, and she has been the maybe most courageous human rights defender in the country. As of June 2019, she had 122 different criminal trials. I'm repeating, 122 criminal trials. Until that date, she received 17 years, 2 months and 20 days imprisonment term and 359,000 Turkish lira fine for human rights activities. Finally, the third person last week received a punishment, not the only three person, of course, but leading human rights defenders. Şebnem Fincancı-Korur, she's the current chair of Medical Associations Union of Turkey. Formerly, she was the chair of Human Rights Foundation of Turkey, a very well-known medical doctor. She was also punished for insulting the then prime minister during Gezi events. You might remember 8 people were killed and many others were injured during Gezi events. And Ms. Korur Fincancı criticized the government and the prime minister for this, and now she was sentenced to fine for criticizing him. So how can this routine judicial exercise can be stopped? Whether the European Court could be an answer. So I think we can follow up some recent judgments of the European Court of Human Rights. A lot of people complain a lot. Even I saw a comment in the chat box that the court is very slow and not always very keen on providing justice to the victims of human rights violations. But still we have some very important cases. One of them is about Alparslan Altan. Alparslan Altan was a member of the Constitutional Court while he was arrested. Some 3,000 judges and prosecutors, including 2 judges of the Turkish Constitutional Court and more than 160 judges of the Turkish Court of Cassation and the Turkish Supreme Administrative Court had been arrested and taken into police custody. Mr. Altan's immunity, along with other judges and prosecutors, was easily lifted by a very flexible interpretation of domestic law. Judges' immunity could only be lifted following a long procedure, as the case in many other countries. However, there is one exception. If a judge is caught while committing a crime that falls within the jurisdiction of the assize courts, then procedure to lift the immunity is not supposed to be followed. Alparslan Altan, as I stated, was a member of the Constitutional Court while he was arrested. So the plenary assembly of the Constitutional Court was supposed to lift his immunity, but what happened? The local courts found that first, the alleged offense of membership of a terrorist organization was an ordinary offense punishable under Article 314 of the Turkish Criminal Code. This is about the membership to terrorist organization, and thus falling within the jurisdiction of the assize court. This was the first condition. Then they said that this offense was a continuing offense according to the Turkish Court of Cassation's recent case law. But this case law was developed after Mr. Altan was arrested. Thirdly, in light of the very specific circumstances of the 15 July attempted coup, this constitutes the factual and legal basis for a case of discovery in flagranto delicto. This flagranto delicto is a Latin word which means that a person is caught during committing a crime. So, of course, Mr. Altan was not caught with a weapon, acting with the soldiers who attempted to overthrow the government. He was sleeping at home with many other people, but the courts held that membership to a terrorist organization is a continuing crime. So whenever you catch a person who belongs to a terrorist organization, can be called in flagrante delicto. So this case is important. Why? Because it was the first case about a judge where the European Court found that the Turkish government violated Article 5 of the European Convention on Human Rights. After him, in Bash versus Turkey, again another judge. This time not a judge of Supreme Court, but an ordinary judge applied to the court, and he also won the case with similar reasons. Now 600 other cases brought by judges and prosecutors are pending before the European Court. But what happened? The government and then the Constitutional Court stated that the European Court has no competence to interpret the domestic law. So they concluded that there is no way to implement the judgment. So both Mr. Altan and Mr. Bash are in prison at the moment. We are talking about judges and prosecutors. So this is critical. Who will provide the justice if you can't provide justice for judges and prosecutors? And I'm coming to another two important cases, and I'll finish there. But before then, I should also emphasize that recently in a couple of judgments concerning the journalists, the European Court decided against Turkey, including Sabuncu and others, Ahmet Şık versus Turkey, Mehmet Altan versus Turkey, Şahin Alpay versus Turkey. However, we heard the name of Ahmet Altan. He applied at the very same day when Mehmet Altan applied to the European Court of Human Rights. And in March 2018, the court decided in favor of Mehmet Altan. But after 3 years, he's still in prison, but there's no judgment, unfortunately, from the European Court of Human Rights. And finally, we're coming to two recent cases. These are very important because these are the first Article 18 cases decided against Turkey. Osman Kavala versus Turkey and Selahattin Demirtas versus Turkey. For non-lawyers, Article 18 is a provision about political detention or use of convention for political reasons. And it states that the restrictions permitted under this convention to the said rights and freedoms shall not be applied for any purpose other than those for which they have been prescribed. But for Osman Kavala and Selahattin Demirtas, there was an ulterior purpose, according to the court. In the Kavala case, to silence a human rights defender. In Demirtas case, it was to silence an opposition politician. However, the government, following the judgments in Kavala and Demirtas was a grand chamber judgment. It was a groundbreaking judgment, which I think summarizes the situation in Turkey about justice and explains how the judicial authorities abused legal notions to convict a leader which represents more than 10% of the Turkish society. But the governments responded first, first president and then the other high-level officials, that they would not recognize the judgment of the European Court of Human Rights. They said that there is no way that those individuals would go free. And even in the Demirtas case, when it was decided first at the chamber, the president said that they would take their own steps to keep him custody. And they really did it. Officially, the Turkish government is informing the Committee of Ministers of the Council of Europe that those judgments have been implemented, because yes, both individuals have been released in the cases examined by the European Court. But yes, what happened? Without physically leaving the prison, they were detained again. And in the case of Mr. Demirtas, he has been in prison for more than 4 years, and in Kavala case for more than 3 years. Now, both cases are pending before the Committee of Ministers. These are very critical, because the question is, how can a rule of law system can survive if the judgments of a court are not respected? Now we are at this level. Turkish government is resisting and claiming that it doesn't have to implement the judgments of the European Court of Human Rights, and unfortunately, politics might prevail over justice before the Committee of Ministers. On between 9 to 11 March next month, not next month, 2 weeks later, both cases will be discussed at the Committee of Ministers, and the Council of Europe will show whether it really sticks to the principles that are founding for the international organizations: rule of law, human rights, and democracy. If we fail there, then I think laws like Magnitsky might be the next step and the question to force countries to implement international judicial decisions. Thank you very much.
Thank you very much, Kerim, for identifying those cases and for highlighting the shortfallings and problems with European Court of Human Rights judgments. And as you say, it suggests that maybe other forms of justice, like the Magnitsky sanctions, will be a better way forward. Thank you very much. Our next speaker is Kevin Dent, QC, who is, I think, going to talk about some of the Gezi Park cases and about the submissions that are being prepared in the UK to hopefully use the Magnitsky sanctions here. Thanks, Kevin.
Good afternoon to all. Yes, I'm Kevin Dent, QC, and I'm lead counsel in the Turkey Human Rights Accountability Project. And we are pursuing an application to the UK government for gross abuses of human rights in Turkey to be placed on the UK Global Sanctions list. My co-counsel, who we'll hear from afterwards, is Michael Polak, and he will talk about some of the particular cases that we are pursuing. But can I start by saying it's wonderful for us this afternoon to hear from some of the real founders and leaders in this new area of law who are an inspiration for our campaign, and to hear the invaluable advice today about how to pursue these applications, and also to learn about how our application can be advanced in combination with others. We are preparing a written application to the UK Foreign and Commonwealth Office and hope to be able to submit it in the next few weeks, or at least the first tranche of our application. Why are we bringing an application? Well, as Dr. Kerim underlines, the problems for human rights in Turkey have now come to a very serious stage. There is a combination of a culture and legal framework of impunity for ill treatment of human rights defenders. that makes Turkey a seriously dangerous place, it seems, to be practicing as a lawyer these days, particularly one defending unpopular causes. And it seems that that impunity is to a considerable extent now enshrined in Turkish law. So that's the difficulties. And the reports about the repression, serious human rights abuses, and lack of effective investigation of those abuses are legion, and they've been reported on many times. And the comments from Dr. Kerem this afternoon only highlight the problems. So there is a very serious problem at the moment in Turkey with human rights, and particularly in relation to lawyers, rights defenders, and other civil society activists who appear very largely to be taking the brunt of the repression. One high-profile example of this from recent years that I witnessed at close hand is the trial of civil society activist Osman Kavala and 15 others on absurd charges that they had plotted back in 2013 together, conspiring together with international powers, of course, to overthrow the Turkish state by organizing a protest against plans to redevelop the Gezi Park in Istanbul. The 16 were all charged on a really Kafkaesque 600-page indictment that disclosed no evidence of any criminality. The European Court of Human Rights, as Dr. Kerem has indicated, ruled that Osman Kavala, who'd been in detention by then for 2 years, should be immediately released from detention. This was ignored by the domestic courts, and he remains in detention. And I was in Istanbul in February 2020 as a trial monitor on behalf of the United Kingdom Bar Human Rights Committee when Osman Kavala and the other defendants were acquitted following trial. And there was very brief jubilation on that day until later on that day, President Erdogan publicly denounced the verdicts, and Osman Kavala was promptly rearrested at the prison gates on equally absurd charges. And it's now clear that he's likely to be detained for a very long time. And the usual checks and balances that would protect his rights are not there, or are simply no longer effective. But we're very conscious in our campaign that figures like Mr. Kavala are powerful and prominent members of society. The situation for those less influential and powerful is far worse. And Michael will, in a few minutes, tell us about some of the cases that we're pursuing. The situation for lawyers, in particularly in Turkey, seems very, very grave, and there seems little, if any, recognition of the role that lawyers play in defending rights. And it seems as though if you are a lawyer defending unpopular causes, be it Kurdish groups, leftists, or others, then the state makes little distinction between you and your client, with catastrophic consequences. And so our campaign has a particular focus on lawyers and those who are defending human rights. At the framework for our application in UK law, the starting point is the 2018 Sanctions and Anti-Money Laundering Act, which largely, in many ways, mirrors the US legislation, in which persons deemed to be involved in serious rights abuses can be placed on the United Kingdom sanctions list. That was the legal framework, and that was then detailed and clarified in regulations from 2020. And those regulations are now in force, and persons involved in serious human rights abuses can be placed on the UK sanctions list if they have been involved in an activity, this is the definition, amounting to a serious violation of an individual's right to life, right not to be subject to torture or cruel, inhumane, or degrading treatment or punishment. So it's quite a wide ambit. Person can be placed on the list if they are involved in such activity. And again, the ambit of what's meant by involved is quite wide. A person is involved if they are responsible for such activity, if they facilitate or incite such activity, if they conceal evidence of such activity, if they provide financial services that will assist such activity, or if they profit financially from them. But in particular, and this is something key to our own campaign, if the person is responsible for the investigation or prosecution of such an activity and intentionally or recklessly fails to fulfill that responsibility. And we are bringing a legal campaign, and we are presenting detailed written submissions to the Foreign and Commonwealth Office. Some would say that an application to place persons within Turkey on a sanctions list would be fruitless, that Turkey is too important a strategic ally to the United Kingdom for these applications to be successful. But we don't feel that way, and we have grounds for optimism. Firstly, the United Kingdom government will have noticed the deterioration of human rights in Turkey in recent years and will recognise the value of taking measures to prevent further decline, and they should be sympathetic to our application and also consider that there is some credibility to our admissions. Secondly, our application is full square in line with United Kingdom guidance issued alongside the sanctions legislation, which stresses the imperative of using the sanctions regime to deter repressions of human rights defenders. That's a clear focus in the government guidance. We also think that there is strong evidence and compelling grounds to act in relation to particular actors in Turkey. And also we're encouraged that the United Kingdom government has already placed citizens of countries such as Saudi Arabia on a sanctions list, indicating that our government is not deterred from putting persons on sanctions lists, even when they are countries that are considered to be allies, which is an encouraging and intelligent approach. Lastly, before giving way to Michael, we consider that our campaign is really in many ways a test case. If the United Kingdom government does impose sanctions on individuals from countries that are considered to be key strategic allies, then this would be a powerful statement that human rights abusers can be deterred anywhere in the world. If governments can see past the flag of the country where the human rights abusers are based and are able to objectively consider individual cases, then you are well on the road towards building a new system of global law, and one that could become extremely important in the years to come. So this is the aim of our application. Lastly, a big thank you to all of the panel, and particularly those who have been a real inspiration to our campaign and to many others. Also, greetings to our brother lawyers like Kerem in Turkey. So kolay gelsin and geçmiş olsun to them, and we hope that the situation will get better than it is currently. Thank you very much.
Thank you very much, Kevin. And if that's okay, we'll then pass right on to his colleague, Michael Polak, who I hope updates us with more details on the work being done here to use the Magnitsky sanction regime in this country against Turkey.
Thank you very much, Owen, for the introduction today. And I'd like to say congratulations to all the organizations and individuals who've put this together. It is really a fantastic event, and I'm humbled to be on a panel with such fantastic speakers. I've been having a look through at the attendees here, and I can see many colleagues from Turkey, but colleagues from all around the world. And this is really an area where we can all work together. It applies across the whole world. So it's fantastic to see great participation. Kevin Dent, Queen's Counsel, has given you a fantastic introduction as to what we're doing, and he's set out the legal framework for what we're doing with the Turkey Human Rights Accountability Project. If you're interested in learning a bit more, please have a look at the website arrestedlawyers.org. They're doing some fantastic work speaking up for lawyers in Turkey who are unable to speak up for themselves in some circumstances. The Global Human Rights Sanctions regime, which is a very new tool for us in the United Kingdom, is a brilliant opportunity to address impunity. It's very early days. This is a 2020 regulation, However, there has been some very encouraging signs, as Kevin alludes to. The first 25 individuals added to the list were in regards to Mr. Magnitsky, which is fitting. The next 19 are Saudi nationals in regards to the murder of the journalist Khashoggi. There's a Burmese general. There's individuals from the Gambia, Venezuela. There's Chechens who are involved in gross human rights abuses against the gay and lesbian community in Chechnya. Pakistanis involved in abuses in Pakistan in regards to arbitrary killing of individuals there, as well as those involved in attacks on the Maidan protesters in Ukraine. So it really is a great list of people to start with. There are some very stark missing individuals, missing people that you'll notice when you look at the list. I'll post in a link to the list. It's all published online, so you can have a look at the individuals. But for example, none of the Chinese nationals who are involved in the gross human rights abuses, crimes against humanity, and possibly even genocide against the Uyghur people are on that list. And it's becoming harder and harder for our government to defend not having those people on that sanctions list as more and more evidence comes out about what's happening to them. Of course, there are no individuals yet on that list in regards to what's going on in Turkey, but we hope to change that. Some of the cases I'll be speaking about, and I'm going to speak about 3 cases in particular, will show the importance of the Magnitsky measures in the United Kingdom. And the reason they're so important is, like in Russia, where Mr. Browder was looking for justice for Mr. Magnitsky and found none using local procedures. Unfortunately, the procedures in Turkey aren't independent or objective at this time. The high-profile cases my colleagues have mentioned before me really does demonstrate that. Now, the 3 cases I mentioned, of course, they're not the only 3 cases. There are other very important cases of torture, arbitrary detention, extrajudicial killings all over Turkey. But these 3 cases give a very good flavor, I think, of why the global human rights sanctions regulations are so important. I have 3 different types of victims. Those who, and it raises issues in regards to the protection of those in custody, the protection of lawyers and human rights defenders, and the imputation of a client's case upon their lawyers, as well as the mass targeting of groups because of their ethnicity. The first case I'd like to speak about is the torture and killing of Gokhan Achikoglu. And I have a picture of him here, so we can really bring home what we're talking about here. And because sometimes at these conferences, we can get perhaps too legal, talking about the legal provisions, and forget what we're really dealing with. He was a history teacher. He was purged following the attempted coup, despite there being no evidence that he was involved at all. He was seized by Istanbul police on the 24th of July 2016 on trumped up charges of coup plotting and terrorism, and it's a common theme amongst those arrested that those charges are used. He was kept in the Istanbul police headquarters for the next 13 days before he died of a heart attack caused by the torture that he was subject to over that period. He was never officially interrogated. The police didn't even take a statement from him. So that really draws into question any statement from the Turkish authorities that he was there to be questioned or for any proper reason. He was taken from his cell every day to face torture, taken to hospital after being tortured, and then rushed back to his cell for the whole thing to repeat again. He told doctors about his abuse and the torture he was facing. In some cases, those complaints were not recorded, but there is plenty of evidence in regards to this case. The torture that Mr. Achikoglu was subject to was being beaten, slapped, kicked in the rib cage, kneed in the back, having his head banged against the wall. He had a medical checkup before he went into custody, and he didn't have any heart problems at all. The evidence in regards to what happened, the emergency services were belatedly called by the police after he had collapsed in custody, although the official records showed that he died at the hospital, but that's not actually true. Professor Shebnem Koro-Finjaj, an expert in forensic medicine, who's head of the Human Rights Foundation of Turkey, he's an executive in the Turkish Medical Association, examined the doctor's reports, the autopsy, and statements regarding the death, and concluded that this death was due to torture. There's been many witnesses, including journalists and other lawyers who were detained alongside him in Istanbul police headquarters, and they've came forward and they've given evidence about the severe beatings that continued for days. These petitions that they've put forward have been ignored by the prosecutor, who's declined to take depositions in regards to the death, and has concluded there was no official was negligent or responsible for his death. Now, as you can imagine, there's a number of people who are responsible and should be subject to the sanctions regime for his killing. And a special point about Turkish law, which I didn't know before I began working on this project, is that prosecutors actually have a responsibility for detainees and to make sure they aren't mistreated like what happened in this case. And that's a particularity. It doesn't apply in English law, but in Turkey, under the constitution, it does apply. As you can see, there are many similarities in this case with what happened to Mr. Magnitsky. The second case I'd like to speak about is in regards to the lawyer Erdem Seme Yildiz. This case has been mentioned by Owen at the very beginning of this conference. I've got a picture of him here as well. And he is a Turkish lawyer who the government of Turkey do not like at all. He acts in all kinds of high-profile cases, including representing the individuals accused of assassinating the Russian ambassador in Turkey. In March 2019, he was seized by the police and taken to Ankara police headquarters. And I did mention that these kind of abuses are spread across Turkey. He was taken there in handcuffs, despite being someone of good character. He was made to kneel in front of a wall. He was asked for his password to his phone, which he refused to give because of privileged correspondence. He was taken to the room of the department manager, abused, and he was told that not a single person left this police station without talking. He was taken back to this room later, and he was physically assaulted there. His clothing was removed on 2 occasions, whilst the department manager threatened to sexually assault him with a police baton if he did not speak. And this is the interesting part of Mr. Yildiz's case, and all this evidence has come out within court records in Turkey. But when he was being tortured, the police who were torturing him were saying things like, "Your clients aren't confessing and giving information about others." So it became clear the reason why they were after him is not because they thought he'd done anything wrong himself, because he'd probably represented his clients and some of his clients hadn't spoken when interviewed. They demanded to know confidential information from his clients as well. In interview, and this is where it becomes quite interesting, the prosecutor said to him again, apparently all of your clients are choosing to remain silent. So it brings about the real reason why he was brought into custody. He noticed as a lawyer the significance of that comment, and he asked that to be added to his written statement, and the prosecutor said it would. But at the end of the interrogation, he looked at the statement and that particular question wasn't there. His lawyers actually tried to add it, but that page was ripped off the front of the statement. The prosecutor, by that stage, having worked out that he'd actually given the game away as to why Mr. Yildiz was actually brought into the police station. Now, this case properly demonstrates the difficulty for lawyers in trying to do their job properly in Turkey. They can be subject to the same torture and poor treatment as their clients. These very brave lawyers on the front line against human rights abusers are being prevented from protecting their clients as they should. Now, this case in particular, you would have heard Kevin speak about the human rights sanctions regulations. One of the government's priorities that they've set out when they're looking for who to add to the sanctions lists is the protection of human rights defenders. So this particular case fits squarely within that human rights priority of the United Kingdom government. The last case I want to talk about, and you would have noticed we haven't just focused on lawyers' cases because abuses against all people in Turkey are very important, and it's very important to bring attention to them. The last case I talk about was a mass torture, if I can term it like that, in Helfeti, in Şanlıurfa. I understand that this is a town with a high percentage of Kurdish population. The evidence from this incident is from many different sources. So we have a 50-year-old woman. She came home at 2 o'clock at night, and 5 people were laid face down in the garden. They were kept like this until 7 a.m. Her son and her husband were beaten. She didn't want to speak much about the torture to herself, but her lawyer spoke about electric shocks to the genitalia. There's a number of other victims of this mass torture in this particular town. I've got a picture of the town here, actually. One of the victims was a man of 60 years old. He had difficulty walking after what he was subject to. He had all kinds of injuries to himself as well. What happens to these people when they try to use the Turkish processes to report their own torture is a very interesting point. One person, when he declared that he was tortured, his statement was interrupted, and he was told that if he mentioned torture, his statement wouldn't be taken by the police. After he decided not to continue mentioning torture, his statement was taken. In other cases, there were threats to continue the detention of individuals. So individuals who said, I've been tortured in detention, would come to tell the prosecution about it and be told, well, do you really want to mention that? Because we're going to send you back exactly where you've just come from. Despite all these allegations, and this is a case really where there are so many witnesses to what's actually taken place, the public prosecutor has not fulfilled his responsibility. There's been no prosecutions or proper investigation. The Sanliurfa Bar Association has complained to the Chief Prosecutor's Office, but nothing has actually taken place there. And they detail a whole list of different types of torture, physical torture, as I've mentioned. Really, really terrible stuff, and the use of electrocution for torture as well. So I hope what I've said to you gives you a bit of a flavor. And these are only 3 cases we've been looking at. There are many cases where there's strong evidence of torture, where the individuals would fit perfectly within the regulations as set out by our Foreign Secretary. We hope that our project can help to address impunity, as the Magnitsky sanction regime all around the world is supposed to do. And I really do take some hope from what Bill Browder says about the effects of the sanctions. And the best possible thing as an international lawyer is when you hear someone complaining about what you're doing. And so hearing about the Russian regime complaining about sanctions there is fantastic. Another example of complaints which show that sanctions do actually have an effect was the chief executive of Hong Kong, Ms. Carrie Lam, who's been sanctioned and cannot hold a bank account or credit card, complaining about having to carry around bags of cash. So these sanctions can have an effect. Not only will they show the world what's happening to individuals in Turkey, but they will have an effect on the individuals who are added to the list. So I thank you very much for having me today. I'm happy to answer any questions at the end about how the regime applies in this country.
Thank you very much indeed, Michael, for highlighting those shocking cases and the terrible, the torture inflicted on people and how people are caught up in the system in Turkey. That's very good to hear, and I hope there will be some justice for them eventually. Our next speaker is Elenora Mongoli, the Vice Chair of the Italian Federation for Human Rights. We're running a little beyond time, but let me pass over to her directly. Thank you, Elenora.
Thank you, and also thank you to the partners for this important discussion. And to all the distinguished speakers we have today, so many essential points have been addressed so far regarding this challenge. So I just would like to try to add something specifically concerning the EU framework. The Italian Federation for Human Rights, as maybe someone already knows, operates in Italy and worldwide for the promotion and the protection of human rights and the rule of law, while conducting monitoring and reporting of human rights violations. We come in contact with the victims of abuses from different countries. We have been following cases, for example, in Turkey, of course, Belarus, Iran, Venezuela, China, and Kazakhstan, where we are currently working to report the mass repression, political killings, and election fraud. These cases show us the wide systematic violation of human rights in the countries led by authoritarian regimes, harassment of activists, lawyers, and media workers, lack of fair trials, tortures, suppression of the right to freedom of expression, the use of the anti-terrorism measures to jail protesters, and even the use of the death penalty to intimidate civil society and to counteract public protests. These cases do not only tell us about individual stories. Behind such stories, there are grave human rights abuses committed systematically and with impunity. All these victims were often human rights defenders, political opponents, investigative journalists, lawyers, and are usually left without justice. And the perpetrators of these abuses enjoy impunity in their own countries. We are talking about countries that in most cases have already been subject to traditional economic sanctions. However, the result is questionable. And the human rights defenders know that there's a great need for a more effective instrument. In this context, the Magnitsky sanctions represent a valuable tool for the protection of human rights, a tool which can avoid the impunity of individuals who are holding key roles in these regimes and are responsible for some of the most serious abuses, can also discourage continuation of certain behavior. And in this sense, we can say they can facilitate the democratic transition. The Magnitsky legislation is, as we have said, is currently being used in several countries. However, as we know, countries implement this legislation in different ways, and its impact obviously depends on how it is designed. For example, the targeted sanctions can also play an important role in combating ground corruption, defined as crimes committed at a high level of government that distort policies or the central functioning of the state, and that can have a devastating impact on the rule of law. And this aspect should not be overlooked, as ground corruption undermines the stability of governments and countries. When responsible of corruption are internationally sanctioned and their assets frozen, their ability to move corrupt money abroad is restricted. And the same with their power to penetrate other countries' politics. However, for such law to be effective and to have a meaningful impact, it is crucial that most states and key international actors like the EU follow the model and support a proper implementation. And even though the cases of ground corruption have not been included, as we know, in the human rights sanction regime, in the European human rights sanction regime, the EU has undertaken its first step to implement such legislation. So in fact, last December, the Foreign Affairs Council adopted these EU Magnitsky sanctions under the name of the EU Global Human Rights Sanction Regime, which seeks to address serious human rights violations and abuses worldwide. But let's see very briefly how this new regime works. It targets individuals, including state and non-state actors and entities responsible for or just involved in serious human rights violations and abuses worldwide. An important point is that it can also target individuals and entities associated with the perpetrators. It covers serious human rights violations and abuses, genocide, crimes against humanity, torture, and other cruel, inhuman, and degrading treatment of punishment, slavery, extrajudicial summary or arbitrary executions and killings, enforced disappearance of persons, arbitrary arrest or detention. And it's also covered other acts such as the trafficking in human rights, in human beings, sexual and gender-based violence, violation or abuses of freedom of peaceful assembly and of association, violations or abuses of freedom of opinion and expression, and violation of abuses of freedom of religious and or belief. So this regime had a broader mandate and only includes individual measures like travel ban and asset freeze, which only apply to the perpetrators listed. The High Representative of the EU for Foreign Affairs and Security Policy and member states can put forward for proposals for listings. And it is then for the Council to decide on those listings. However, according to us, there are still serious concerns with this legislation. The first one is that these sanctions require unanimous agreement and not qualified majority. And as we know, this can often be difficult to achieve and can put obstacles in the way of its potential effectiveness. The second one is that, as already mentioned, the legislation doesn't mention corruption. And the third one is that NGOs are not allowed to point the fingers at human rights offenders. So last Wednesday, the foreign ministers of the EU agreed to impose travel bans and asset freezes on 4 individuals, those responsible for Navalny's arrest, sentencing and persecution. And this would be the first use of this new sanction regime. However, this draft list does not mention Russian oligarchs who benefit from his arrest and whose corruption has been exposed by Navalny. And the reason, according to Borrell, is the lack of evidence. So in that sense, we know that there's still a lot to do in order to have a tool that can really make a difference. But we should keep on working on the weak points on this EU new regime that obviously we are happy to have. This should be a tool which empowers individuals and civil society, as their participation is an added value in the process of uncovering human rights and in the process of collecting evidence. Also, this is a tool to be used in coordination with the other countries. Countries which use the Magnitsky Law should act together to combat impunity. And the global and cross cooperation in the process of targeting perpetrators is crucial. That's why we also should continue to urge the member states to adopt their own legislation. So thank you.
Thank you very much, Elenora, for setting out the drawbacks and but possible future for the operation. And can I pass over now to Francesco Kaya, who will talk about his experiences and the situation of lawyers in Turkey. Thank you.
Hello. Good afternoon to everyone. I would like to thank Arrested Lawyer Initiative for promoting this event and all of the distinguished speakers and the representative of the association participating to this important conference on a topic which is central to the defense of human rights at the global level. On behalf of the Consiglio Nazionale Forense, I am pleased to have the opportunity to speak as a rapporteur and to be here with you today. Unfortunately, the current global situation is marked by an increase in human rights violation, albeit in very different geopolitical contexts and realities. The common denominator, which links violation of fundamental rights at all levels, when they are carried out by authoritarian governments or state bodies and concern lawyers, independent judges, journalists, and human rights defenders, is the repression of dissent. There is, therefore, a strong need for the adoption of a comprehensive sanctions regime to combat gross violation of human rights. This regime should address not states, but officials or individuals linked to the governments of illiberal countries who commit human rights violations. The Consiglio Nazionale Forense is strongly committed to defense of human rights. And today I talk about the many initiatives carried out by the Consiglio Nazionale Forense. I would like to mention the work carried out in relation to the serious violation of fundamental rights in Turkey, a country where is well known. There is a real persecution against lawyers who are only guilty of doing their duty in the interest of their clients with autonomy and independence. In fact, it is precisely the independence of the legal profession that is targeted through the identification of the lawyer with the client. Often leads to investigation, arrest, and heavy sentences for complicity in serious offenses such as participation in or promotion of a terrorist association. Criminal proceedings against lawyers, as well as those against independent judges, journalists, academics, human rights defenders, are marked by serious violation of the rights of defense and fair trial. This is what was threatened, for example, by the international mission of lawyers in which the Consiglio Nazionale Forense participated, which in October 2019 went on a mission to Istanbul, among other things, the Silivri prison, where the lawyer Ebru Tintik was detained. It is well known, unfortunately, Ebru Tintik died on 27 of August 2020 after 238 days of hunger strike. She had been sentenced to 13 years and 6 months imprisonment and had gone on a hunger strike to demand the independence of the judiciary, respect for fundamental rights, and the rules of the due process. She died as a result of the rejection of all requests to release her from prison on the ground of her very serious health condition, and despite appeal by the entire international bar community and many international human rights associations. Her trial was characterized by very serious violation of the most elementary rules of procedure and of the right of defense with recourse to so-called surrogate witness, preventing a real cross-examination. The defense lawyers were not allowed to carry out their defense mandate properly. In recent years, the Consiglio Nazionale Forense has participated in several international observation missions of trials of lawyers in Turkey. In order to coordinate its action with that of the representative of other European institutional bars and law society, in 2016, the Consiglio Nazionale Forense with the Conseil National de Barreau, the Paris Bar Association, the General Council of the Spanish Bar, founded the International Observatory of Intelligent Lawyers, which is based in Paris. The observatory ensures permanent monitoring of the situation of lawyers who are persecuted or threatened around the world because of the exercise of their profession. The observatory drafts requested a petition to governments to demand the respect for human rights in relation to specific cases and organize a mission to observe trials of lawyers. The observatory has support, including with practical assistance, several colleagues who, after having been forced into exile, had to apply for refugee status because remaining in their own country means putting their lives at risk. Also provides initial financial aid or social or medical assistance. If then provides legal assistance in applying for refugee status. On these issues, we managed to achieve a strong synergy with the Arrested Lawyer Initiative, whose representatives were received at the Consiglio Nazionale Forense during the proceeding of the Hoyad General Assembly, which has held in Madrid on 21 October 2019. Two representatives of the Arrested Lawyer Initiative addressed those present on the dramatic situation in Turkey. On the occasion of the 5th of April 2020, Lawyers' Days in Turkey, the Consiglio Nazionale Forense edited the publication in Italian of the report of the Arrested Lawyer Initiative on the repression of lawyers in Turkey. Some copies of the text have also been published in English. On 10 of December 2020, on the occasion of World Human Rights Day, Oskun Yorulmaz, from Arrested Lawyer, participated in the online event organized by the Consiglio Nazionale Forense, which is valuable by the dramatic testimony. The commitment of lawyers and the legal representatives on these issues is fundamental about to ensure support for lawyers unjustly prosecuted and retaliated against by the governments that intended to silence and dissenting voices, and to inform and raise public awareness on the issue of extraordinary importance for our future and that of our children, the affirmation of the unalienable social rule of the legal profession. Sorry, but for more committed, I have to leave the conference now. Congratulations for the excellent initiative and the good evening to all.
Thank you very much, Francesca, for that summary. Now, look, we still have some time left, so I hope you will send in any questions you'd like to ask about the way Magnitsky sanctions will work, and about the difficulties there will be in imposing them on Turkish officials. Perhaps I could ask, I suspect Bill Browder may not be with us anymore, having moved on to his next appointment, but perhaps I could ask Amanda and Kevin about the way in which I must admit, when I first wrote about it last year, I thought that Turkey being an ally in NATO, it would be difficult to impose sanctions on a friendly country. But I must admit, the more I've heard today, the more widespread the practice is becoming, perhaps, and it's the more acceptable it will be to use it just against individuals, which will not be seen as disapproving of a whole country, but will allow such punishments to be targeted more carefully. I don't know whether that's something you feel as well.
Sure, yeah, I think that's, you pointed exactly to one of the real benefits of the Global Magnitsky Sanctions approach, is it allows the US or other governments with similar sanctions programs to target specific individuals in a way that hopefully doesn't do as much to disrupt the bilateral relationship between the sanctioning country, here the US, and the country of the where the individual perpetrator is a national. I think ultimately it comes down to a matter of the particulars of each individual case, of each individual perpetrator, and from the US's perspective, what their national interest is there. We've seen a number of cases brought forward against individuals who we feel there's very credible evidence to point to their involvement in serious human rights abuses. But because they're from countries where the US has more friendly relations, or you maybe see some strategic advantage to those relations that maybe perhaps playing into the decision whether or not to sanction them. The US also has a number of other measures that they may take that allow for more limited consequences against individuals. For example, the State Department has a visa restrictions program that they don't have to announce publicly. So it's not that there wouldn't be action being taken, it just might not be making it into headlines, which obviously can be a bit frustrating for activists and lawyers working to push these issues. But yeah, I think ultimately it comes down to a case-by-case basis. And I think to the extent that there are those individuals who you are causing, being involved in serious human rights abuses, And to the extent that both the US and the other country where this person is operating maybe agree that they are not in the best interest of those countries going forward, that might open the door for a easier sanctions designation. But it's certainly something that the US government is weighing as it looks at all of the diplomatic tools it might be considering using to respond to any given situation.
Thank you. Yeah. Thanks. Very good. I don't know whether Kevin wanted to make comments on that or Michael.
Just a brief comment. And I think firstly, we can hear from Amanda that the United States is some way further along the line than the UK government. It's very early stages. And so we don't know really yet how the UK government is going to approach looking at different countries. But there are encouraging signs, particularly the designation of a number of people involved, Saudi nationals who are involved in the killing of Jamal Khashoggi is encouraging. And we'd like to think that the UK government will be able to distinguish between, on the one hand, countries that it would like to develop and foster good relationships with, and on the other hand, being able to distinguish within those countries people, individuals who are bad actors, and that the two don't necessarily, no reason really why the two shouldn't go hand in hand. And it may be, and again, Amanda will have more experience of this, it may well be that one of the things to be learned from this is making applications in respect of persons at the right level, and so sufficiently prominent abusers to make it strategically important that they be placed on a list, but not so powerful that it would become a serious political problem if they were to be put on a list. And that's just one approach. But yes, so far, encouraging signs.
Thank you very much, Kevin. Can I ask Kerem, perhaps, who is in Turkey? I know he's keen, and he's asking how can people abroad help human rights defenders. But I've been asked to put it, I mean, how much will sanctions against individuals be seen as a deterrent within Turkey if they are imposed on human rights violators, Kerem?
I think, I mean, I'm not very optimistic on this point because my door is buzzing anyway. It's about the political will of those governments. When the state of emergency was imposed in Turkey, I received very similar questions. What can we do for you? And to the foreign politicians and diplomats, I said that, why don't you take Turkey to the European Court of Human Rights as a state? When there was a systematic and widespread human rights violation allegations at that time. And now, again, we have the same problem before the Committee of Ministers, although it wasn't officially confirmed. But what I heard is some governments at the Committee of Ministers do not want to initiate the infringement process before the European Court of Human Rights. It's again about political will, because some governments, I'm not just talking about Russians, Hungarian or Polish government, but some Western governments as well. They might act with this autocratic governments not to initiate the infringement procedure. The reason is that they don't want to alienate the Turkish government. As you already stated, this is an ally in Middle East. This is a NATO member, so we shouldn't alienate the Turkish government. So we can delay the infringement procedure before the European Court of Human Rights. If they don't want to do this, how can we trust those governments that they can initiate some sanctions imposed on individuals. It's more risky. I mean, assume that a high-level politician in Turkey is sanctioned by a European country. I'm leaving the United States apart because it already happened, but not about a Turkish individual, by the way. The question is whether the US government would like to do the same thing about a Turkish individual, not an American citizen. That's critical. And I have suspicions about this. And when it comes to the question, what can we do for you? I think you can put some pressure on Turkish government about the new associations law, because both the activities of human rights NGOs in Turkey and international or foreign NGOs that want to conduct activities in Turkey will be under huge pressure after the new amendment made in the association law. And I think there is a lot of place to discuss and to criticize this. A group of special reporters at the United Nations already released a report about the new Turkish amendment on the law of associations. I think this is the most alarming thing about human rights defenders in Turkey at the moment. So I think we need more support from international NGOs to bring this to the discussion at international level.
Thank you, Kerim. Can I just ask, I mean, there are a number of lawyers and other people who very bravely go and observe cases in Turkey. Does that have an effect, the presence of foreign observers? And have there been problems for foreign observers? Have they been obstructed by the Turkish authorities?
I'm a consultant to the ICJ, Owen, International Commission of Jurists. So ICJ, along with International Bar Association, monitored the Gezi trial. I think it has been useful, and it helps people to understand what's happening in Turkey. But the problem is there are too many cases, and all international observers are following the same cases. I think we need to develop a strategy that some other cases around the country can be monitored and reported back to the international observers. So that's why, rather than monitoring only some leading cases, a strategy needs to be developed to monitor low-profile cases, maybe not as important as Osman Kavala, but still represents the situation in the country. I think this is another area where international NGOs can work with national NGOs to develop a strategy on this. But it's definitely very useful, monitoring those cases.
That's very good here. Thank you very much, Kerim. Thank you. I wonder, maybe I could ask Michael Polak. We should obviously cherish the European Court of Human Rights and all its efforts, but it can be very slow. And in the case of Turkey, we heard sometimes governments have unfortunately began to refuse to implement judgments in some areas. I mean, do you think the Magnitsky sanctions are going to provide a much faster route to trying to deliver international disapproval and will be taken up much more widely by lawyers in future?
Potentially, yes. In regards to the evidentiary standards, it's a lot easier to make submissions to a government or foreign ministry than it is to set out arguments in a court. And the European Court of Human Rights does fantastic work, and we're very lucky to have it. But it does take a long time to actually get to the result. And then there is the question about actually getting states to comply with the results as well. I think the international community should do more, because if countries want to have the benefit of being part of the court, and states really do enjoy being part of it, in that they can say, well, we're a country which abides by these types of values, then they should be forced to comply with judgments. But I think sanctions it's another tactic. So it's part of, in regards to countering impunity, I see it like a whole sheaf of different weapons, perhaps. And the Magnitsky sanctions are one weapon. And I know Bill Browder talked about universal jurisdiction and his problems trying to use universal jurisdiction as another weapon. But just recently, I think yesterday in Germany, there was a conviction for someone involved in the Syria conflict as well. So it is usable in some countries. And for us as international lawyers, the challenge is how to use all these different modes of all these different weapons together. So I would never say to anyone, just concentrate on Magnitsky sanctions, but they are a very useful tactic. There's so many different options around the world. In the United States, you've got the Aliens Tort Act, you've got private prosecutions in the United Kingdom, which can be used in some cases. You've got the European Court of Human Rights, you've got all the human rights committees of the United Nations. So there are so many opportunities to look at. And often it's difficult when you have a case to find out what's the best weapon to go with. But I think it does add a lot. And we're very excited about having this opportunity in the United Kingdom to use our own regime. But I think it's very important to remember, just because we've got our own regime in the United Kingdom, that for them to be effective, it must be used together. There's not much point in us having sanctions of a Turkish individual in London if that individual can do banking in Belgium. So it is really important to realize this is a global scheme. And what's been quite, I think, I'm sorry, I'm going on a bit, but what's been quite welcome recently is states acting together in sanctions. In regards to the Lukashenko regime in Belarus, Canada and the United Kingdom made their sanction decision at exactly the same time. And I hope to see more of that stretching out across the world, countries using sanctioning together. And it gets around some of the impasses with the United Nations.
Thanks very much, Michael. That's and one of the other questions that I think Kevin was alluding to was about working out what level of official should be targeted. In some of these cases, there is obviously the potential for identifying and targeting an individual prison officer, police officer. And what thoughts do people have about going for those lower officials who themselves, it might sometimes be thought, are acting under duress as well, even if they are also the perpetrators at the same time?
I don't know if you want me to jump in quickly on that, but the UK regime is set up to target individuals which will have an effect on a country's behavior. So if you're going too low level, I don't think you'll get people listed. But if you're talking about the head of a police station or a judge who's sending people to arbitrary detention and to torture, that's the kind of level I think would be a starting point. There's no reason why you can't make applications against people at the highest level. Lukashenko's on our list, so you've got the president of Belarus. But at the same time, if you make applications on a few different levels, then it might be that the government says, well, we're not going for the top because that might damage business too much. But these people in the middle, who are really causing a lot of the damage, are the ones we should be looking at.
That's great. Thank you very much, Michael. Now, are there any other questions other people would like to send in? We've heard from a fantastic array of experts who've delivered lots of different perspectives on the terrible situation in Turkey. And I'm sure a lot of it has been very encouraging in the potential for action that the Magnitsky sanctions bring along. So if I was working on The Guardian, I would look forward to writing cases in the coming months, one would hope, about government actually taking action. And it is great to see the potential. But if there are any other questions, do please send them in. I suspect we've probably reached our full time now. So can I just thank everybody for their contributions, particularly sorry, I clicked off for some reason. It's great to hear people from all around the world. I'm sure we'd all like to be in one room, but at least like this, we can bring together people from all over the world to focus on this. Can I also thank those organisers behind the scenes, Ali and Josh at the Arrested Lawyers Initiative, who've organised this, and Brian O'Connor and Sadiq Sina, who's helped bring it all together. So I should probably wrap it up there. Thank you very much indeed for your contributions. And I hope there will be success and the governments will be moved to intervene in Turkey, and that will have an effect. Thank you very much.
Thank you very much for presiding today in our talk. And can we thank all of the wonderful contributors today? We really have learned a lot. Thank you very much, everyone.